NACDL is the association of the nation's criminal defense bar.
There you go again, Batson and jury selection. And I chose the title, There You Go Again, in deference, obviously, to former President Ronald Reagan and his fabulous "There you go again" line against Jimmy Carter in the presidential debates. Not just because all any of us can watch nowadays is pre-presidential debates, but I thought it was both descriptive of what we need to be saying to win our Batson claims, both in showing that there they go again, and they're doing it again and again, but also the deftness with which it was deployed. We need to find a way to shut down the other side and their bogus excuses and get to the heart of the Batson claims in our cases. So I wanted to start just by way of introduction saying that there are a few things I take as an article of faith. One of them is that prosecutors are using race and racial stereotypes as a substantial motivation in their use of peremptory challenges. Now, I don't know where you all are from, but I practice here in Louisiana and in Mississippi and Texas, and that's how it is. We actually have the advantage in Louisiana of having done a lot of digging and research on this, and the slide I'm showing you now is showing you the percentage of black jurors compared to non-black jurors peremptorily struck by prosecutors in 3 of our largest jurisdictions, Caddo Parish, which is Shreveport, the last home of the Confederacy up there in northwest Louisiana, Baton Rouge, and Jefferson Parish, which is where you landed at the airport when you flew into New Orleans, the white flight suburbs of New Orleans. What you're seeing there is that, and this is based on a series of studies taking into account 8 and 10 years of data of virtually every trial in each one of those parishes, or counties as everyone else likes to call them. And it shows that time and time again, when you add it up, the prosecution are striking about 45% of African American prospective jurors and only about 15% of white prospective jurors, over and over and over again. And so it would be like me coming into this room and saying to this half of the room, I want half of you now to stand up and get out. You're out of the training. And then walk over to this side of the room and say, look across your row, count to 7. I want each 7th person to get up and go out. So 1 from that row, 1 from that row, 1 from that row, 2 there, and kick out not half like this side, but only 6 or 8 people from this side. If I did that, everyone would clearly understand that I had something against this side of the room and that there was something going on. That's exactly what's going on in our courts. So why aren't we winning all of these Batson challenges? Why aren't we bringing more Batson challenges? Because this is the reality within which we practice. So we're not bringing enough of these claims. We're losing them when we bring them. And in some jurisdictions, we're losing reverse Batson claims where courts are upholding retaliatory prosecution claims that defense lawyers are perpetuating centuries of oppression of white males by excluding white males at an excessive rate. And we're losing those claims. The problem in our courts is not that all the white people are being kicked off the jury. So how are we losing those claims? Are you filming this? I must be driving you nuts. You want me to stand still? All right. You'd think I'd be more aware of a camera in this day and age, but so how are we losing these things? And I want to hopefully give folks some tools to use to have confidence in bringing their Batson challenges and a way to get them over the line, to win those challenges, because we are dealing with really an existential problem in justice in our justice system, and we need to do a better job. And I'm going to focus very heavily on the United States Supreme Court's case from June this year, in Flowers versus Mississippi, Curtis Flowers' case. Not because it's got a podcast, not because it has extraordinary facts that you're not going to find in most of your cases, I hope, but because in that case, the majority of the United States Supreme Court has given us a really valuable toolkit all in one place that we can use. And I want to go through that. But I want to start, first of all, by making the point to a group of defense lawyers. Don't strike jurors based on race or racial assumptions. You should not do that. It is illegal. It violates the Equal Protection Clause of the federal Constitution. We are liberty's last champion. I think you can buy hats that say that out there in the foyer, and it ill behooves liberty's last champion to violate the Bill of Rights. We actually don't have many bits of the Bill of Rights that we have to abide by, right? And we complain about prosecutors violating the Bill of Rights all the time. So this is one we're meant to abide by. Consistent with our zealous advocacy for our clients, it is illegal for us to base our strikes in substantial part on race. It is also unethical to do that. If you look at the model code, because all of the codes in the different states vary, the model code prohibits lawyers engaging in conduct that you know or reasonably should know is harassment or discrimination on the basis of race, national origin, or ethnicity. We actually have a case in Louisiana where a lawyer was disciplined when he conceded that he was removing Caucasian jurors from a jury panel solely because of their race, which ended up in a mistrial, because that's what happens if a defense lawyer does it. So it is illegal, it is unethical, but it is also bad practice. If you're sitting there saying, don't give me illegal and unethical, I've got to win, or I've got to do something to counteract what the prosecutor's doing, it is bad practice. There's that, to borrow a line from Samuel L. Jackson, when you make an assumption, you make an ass out of you and umption. And that's what you're doing when you say, well, I know the black jurors are going to be better for me because most of the victims of violent crime in my city are black and most of the community's being terrorized by crime are black and they're probably sick of it. And it's an idiotic assumption. You can make those assumptions when you're sitting around in a bar having a chat or having a coffee on the weekend or what have you. But your client's case is no place to make assumptions that can be so clearly wrong. If you want to find out what a juror's attitude is to law enforcement, to crime in their neighbourhood, to drug crimes, to crimes of violence, you need to ask them and you need to listen to their answer and not think that you know what they mean because of the colour of their skin or their ethnicity. So it is, to my mind, just per se bad practice to use those assumptions because you're just guessing, and we shouldn't guess on our client's liberty. So a very quick primer on Batson, or primer, called a primer in Australia. I'm trying to hang on to, I've been here 17 years, I'm trying to hang on to a little bit. Banana, things like that. They make a difference. So Batson evolved from a period when there was no protection from discriminatory strikes. Even after the 14th Amendment was passed, even after Strata versus West Virginia said you can't exclude people from jury service based on race, for a very long time there was no protection. Peremptory strikes were sacrosanct, you can't bring equal protection into that. And Batson is an evolution of an attempt to bring that basic concept of equal protection into play in the use of a discretionary decision authorised under colour of state law to exclude people from jury service. And in applying equal protection, understanding that that's what's going on with Batson, understand that the way in which it's framed is an equal protection right of the defendant and of the juror, which is why defence lawyers can violate it as well. And the equal protection rule is that an attorney may not discriminate on the basis of race when exercising peremptory challenges. A prosecuting attorney, a defence attorney, a civil attorney. That is, an attorney cannot strike based on assumptions made because of juror race. That's what we're talking about, and I'm going to come back to that. We're not saying you have to hate white people or hate black people to violate Batson. One of the great Batson violators in Louisiana is an African-American prosecutor who, if he said it once, he said it a dozen times in response to Batson objections. Well, I'm black, so it's not about race, which I'll tell you a story in a minute, is demonstrably untrue. It is true that he is African-American, but it is also true that his strikes are at times race-based. It's not about race hate, it's about assumptions and it's about stereotypes. The rule applies regardless of the race of the defendant or the juror, and even a single instance of racial discrimination is enough. So we talk about these cases where all of the black jurors were excluded. You don't need that. You can win a Batson challenge in a case where the prosecutor accepts black jurors hand over fist, half a dozen members of the jury, but then you catch them in an assumption based on race about a juror, and that's enough. Just one is enough. You're not going to have that case very often, I grant you, but only one. And that's been very important in Louisiana because, as some of you know, we've laboured under a majority verdict system for 100 years, and prosecutors would routinely leave one or two African-American jurors on because they didn't care, because they figured all the white folks were going to club together and get 10 votes. And even our Supreme Court, the Louisiana Supreme Court, recognised that and said, well, that could just be a strategy. So that's what equal protection is trying to do. And so then we get to the Batson framework. I'm sure most of you are familiar with it. I'm going to deal with it very quickly. 3-step test. Step 1, and I'm just going to assume we're talking about defence lawyers making Batson objections against prosecutors. So I'm going to talk about defence lawyers and prosecutors. Step 1, the defence lawyer needs to show a prima facie case. All you need to do is point to something that gives rise to an inference of racial discrimination. That's in Batson. That's all you need to do, because you're talking about a cognizable group and the exercise of state power, the discretionary strike power given to you by statute or constitution. All you need to do is point to a system that permits discrimination. You just need to point to something that gives rise to an inference. Once you do that, a burden of production shifts to the prosecutor to produce race-neutral reasons. That sounds like a relatively simple exercise, but it has not always been so. The first Batson case, 18 years after Batson, that the Louisiana Supreme Court granted relief in, the prosecutor said, well, I struck him because he's a single black male. Usually, if you stick the word black in there, it's going to be hard to argue that it's race neutral. But in that case, the district court judge said, yeah, that's a race neutral reason. And even the Louisiana Supreme Court, and I hate to use the phrase even the Louisiana Supreme Court, but I'm going to keep doing it. Even the Louisiana Supreme Court said, well, you can't say black. You know, we're giving you a pass on every Batson case since Batson came out for 17 or 18 years. But you can't say black in the reason. But it's not just that. The reason can't be just general assurances. Judge, I don't see colour. I'm a post-racial kind of prosecuting guy. It can't be based on assumptions about race. It's not enough to say, well, I don't hate black people, but I just think that, you know, with the way crime and drugs are, blah, blah, I think black people are, or I think it's a black defendant, I think they're going to identify more with him, or I think it's a black defence lawyer, I think they're going to identify with him. It can't be that. And it has to be a reason related to the particular case to be tried. And I think that's a part of Batson. That's a phrase, I'm quoting directly from Batson, that's a phrase we don't use enough to skewer the prosecution reason. Once they produce their reason, you go to step 3. And that is where the burden is back on us to prove by a preponderance discriminatory intent. Not just discriminatory effect. It's not enough to point to how many people have been excluded. We've got to prove discriminatory intent by a preponderance. And what the court in Flowers makes really clear is, once the prosecutors come up with race-neutral reasons, that kind of boils down to deciding whether or not those race-neutral reasons are the actual reasons or a pretext. So what we're doing in step 3 is rebutting the race-neutral reasons offered by the prosecution. I'm going to come back to step 3 as well, because I think it's one of the areas we're getting hosed. How many of you have made a Batson objection, the prosecutor gets up and gives their race-neutral reason, and the next thing that happens is not, Mr. Bourke, do you have any rebuttal or anything else to say, but is, well, I accept that race-neutral reason. Judges eliminate the 3rd step. They eliminate our rebuttal of the race-neutral reason, and we need to get back in that space and make our points through argument and evidence. So they're the 3 steps of Batson. Flowers versus Mississippi, you need to read this case. If you try cases in front of a jury, you need to read this case. I included it in the materials in case anyone still reads things in paper, but you need to read this case. It's a striking and infamous case, 6 trials, constantly excluding all the African-American jurors except one, etc., etc. You're probably not going to have those facts, and the prosecutor's going to say, well, this isn't Curtis Flowers' case. You need to be ready for that, and the best way to get ready for it is to read the case. It contains a good, relatively detailed review of how we got to Batson, from the 14th Amendment being promulgated all the way up to Batson and the post-Batson jurisprudence. It has an astonishingly detailed and sympathetic description of how to establish discrimination. It's not just a list of, well, you look at this and you look at that. There are descriptions about how a prosecutor might do this to obscure their discriminatory intent, and so you need to look at this to get around it. It is a remarkably sympathetic rendition. It creates no new law. It says so. It just gathers the existing law, which only adds to its strength. The other thing you need to read is the dissent. Justice Thomas fired off a very heated dissent. And you need to read it for 2 reasons. One is because, generally you need to read the dissent to better understand what the majority rejected, right? And the majority in Flowers said, not only is it clear to us that there was racial discrimination, it is so obviously clear that even with the enormous deference we give the trial court, we are going to reverse here because it's so obvious. And Justice Thomas said, not only is it not obvious there was an abuse of discretion, there absolutely wasn't, because it's so obvious there was no racial discrimination in the jury selection. And of course, he commanded his vote and Justice Gorsuch's vote. So that was rejected, but that is how sharp the split is. And how Thomas characterises what happened is how prosecutors and unhelpful judges will characterise what is happening in your case. And you need to be able to say in some detail, no. That's what Justice Thomas tried to argue in Flowers, and it got completely rejected. I thought about going through it, but it's just too long. It's its own presentation to go through that back and forth, but it's really important. You should read the dissent. I'm getting up here telling you to read a case and to read the dissent. I'm going to get rotten fruit thrown at me in a minute. So it's still the United States Supreme Court, so Flowers giveth and Flowers taketh away. What does it give us? It gives us a great step-by-step guide on how to establish discrimination. What does it take away? Nothing new, but it emphasises in the starkest possible terms that enforcing Batson is the job of trial courts and appellate review is highly deferential. So as trial lawyers, the buck stops with us. Don't be thinking it's going to get cleaned up by the appellate lawyer. It's our job to create the record, and when the appellate lawyer gets the case, they are burdened with one of the most deferential standards in direct appellate work. And Flowers emphasises that. So we have to do the work at the trial level. One of the things that they do in Flowers, and I extracted it in the outline I put in the materials, the majority, which was written by Justice Kavanaugh, lists out these 6 things that courts take into account. It's not an exclusive list, and I'm going to go through them all one by one, but they're listed out in dot points in the opinion, and then the court goes through them one by one. It is, as I say, a really great step-by-step guide on how to do this. So, statistical evidence, disparate questioning, side-by-side comparisons, prosecutorial misrepresentation, history of prosecution strikes, and other circumstances. You don't need to read any of that. I'm going to go through them now one by one. So, statistical evidence. What they're talking about here is statistical evidence in your case. What is the pattern of strikes in your voir dire, in your case right then? This comes from Batson. Batson talks about a pattern of strikes. And as I said before, the Louisiana Supreme Court and the United States Supreme Court have clearly stated that it doesn't need to be the exclusion of all African American jurors to amount to a pattern of strikes. And indeed, the United States Supreme Court in Millerell and in Flowers, and I've got like the cite to Millerell and the cite to Flowers in the notes that are in your materials, have said that accepting one black juror can be a strategy to obscure the pattern of otherwise striking based on racial assumptions. So the pattern is not they struck all of the white folks or all of the black folks. It can be more careful than that. Now, I appreciate that most of my work is capital work and we end up getting more time in our capital cases for voir dire, and we're voir diring larger pools than we usually get to do in our non-capital cases. But I wanted to share with you some of the tools that we use in our capital cases to manage this. How are you going to keep track of this? You can keep track of it on your yellow legal pad, but you can also rely on just very simple technology like an Excel spreadsheet that you are filling out or having someone who's assisting you fill out. One theme that I'm going to come back to is that you can't do modern voir dire and prove up a Batson objection on your own. You need someone there helping you during voir dire. Hopefully someone who knows how to use Excel, for instance, if you don't. You set up an Excel spreadsheet. It's got the juror number, their last name, their race, their gender. You can have information about what panel they were on, the panel date, and then you can look at what were the grounds on which they were struck for cause, because you may be wanting to deal with that. How many of them were challenged for cause by the state, that sort of thing. And you can record what their outcomes were in voir dire, and then you can filter it and look at who was kicked out and who wasn't kicked out because of hardship or cause challenges, and get down to our qualified jurors and start recording who had a defense peremptory, who had a state peremptory. You can all see that in those columns. You can be doing that in live time. And then you can have these other tabs which will tell you what's the breakdown, racial breakdown on the cause grounds. What's the racial breakdown on the general voir dire outcomes, and critically, what's the racial breakdown on your general voir dire? Let me get this thing off the screen there on the right. What's the racial breakdown on your peremptory strikes, I should say? And you can see that as you enter this data line by line, this will update and tell you that the state has accepted 22% of black jurors and 92% of white jurors. That's pretty striking. And then you can have this number down the bottom here, the black strike rate, as we call it in Louisiana. They're striking black jurors at 3.5 times the rate they're striking white jurors. And you can have that happening for you as you sit there in trial, and when you go into your conference to do this, the peremptory strikes and make your challenge, you can say, Judge, they've accepted 2 black jurors out of 9, 11 out of 12 white jurors. That's 22%, 92%. That's a 3.5 ratio. And you have that at your fingertips. You can also ask Excel to calculate the statistical significance of that. If you want to, and you want someone who's got only a little bit of talent with Excel, you can add a little box there that does either a chi-square test or a Fisher exact test, and will tell you the chances of that strike pattern being unrelated to race is only 1 in 10,000, or a statistically significant pattern. And you get denied, and you keep going with voir dire, and you come back to your full table of people, and you handle a couple of more jurors. And the next juror is accepted. So you punch in that they've been selected as a juror. And then the next juror, the prosecution strike again. So you punch in that it's a state peremptory. You come back over here, you need to refresh the table the way that I've set it up. And look at that. Now our black strike rate has increased to 4 times the rate. So you can get these up to the minute statistics as you're going along in voir dire, and you can have your assistant be telling you before you get up and argue so that you can make those points directly to the court and preserve them in the trial court record. All of this requires careful note-taking and a support team. Lots of you have people in your offices or associated with your offices who can do that. We use law student volunteers, undergraduate volunteers. With the employment market the way it is, it's actually proven relatively easy now for us to attract people who want to come and be able to put on their resume, I spent 3 months interning, or I went and was a trial assistant on half a dozen trials. So be creative, think who you can get, but don't go into voir dire alone. And then preserve the objection on this basis in the trial court, because if you don't say it in the trial court, there's a better than average chance it'll be defaulted on appeal. Disparate questioning. This was the second of the 6 things the court said that courts could take into account. Disparate questioning of black and white jurors. That can be quantitative or qualitative. Now, what do I mean by that? I mean quantitative. Prosecutors can ask black prospective jurors more questions and more follow-up questions, like literally numerically more questions. And that was Flowers versus Mississippi. Qualitative can be that prosecutors have a different script. They have their strike script. I want to get rid of that juror. Not that anyone in here would have one of those scripts, right? But I've got some questions I know I can usually bust out a challenge on or come up with a race-neutral reason on. I've got a black juror. I'm going to ask this set of 15 questions that I'm not asking the white jurors. And that was Miller L. They had a different script that they used. So the United States Supreme Court has recognized both of those things as illegitimate disparate questioning. And one of the things that's really astonishing to me about the decision in Flowers, is there anything on that screen? I'm going to read from a piece of paper anyway. One of the things that's really astonishing to me is just how sensitive and sympathetic the court is to the way in which this can be used to disguise discriminatory intent. First, the court quoted Miller L saying, as Miller L stated, if the use of disparate questioning is determined by race at the outset, so if you know you're going to go after the black jurors with the other script or ask them more questions, it's likely that a justification for a strike based on the resulting divergent views would be pretextual. In this context, the differences in the question posed by the prosecutors are some evidence of purposeful discrimination. So what they're saying there is, yeah, you came up with a race-neutral reason, and yes, it is race-neutral, and the juror did say that. But the only reason you came up with that is because you asked the black jurors those questions and not the white jurors. So even though you've got a race-neutral reason out of your questioning, you still lose, Mr. Prosecutor, because it's tainted root and branch by your decision to only ask black jurors those questions. That's an incredibly powerful tool for us. We're not stuck with the fact they got a juror to say something they can hang their hat on if we can show that they went hunting for that against black jurors and not white jurors. So this is to come back to Flowers, and I want to read these quotes because I think they're very powerful for us. Disparate questioning and investigation of prospective jurors on the basis of race can arm a prosecutor with seemingly race-neutral reasons to strike the prospective jurors of a particular race. So we understand that. But I had no idea that any of the Supreme Court justices understood that. They never said anything that made me think they understood that. That you're asking these disparate questions to come up with a race-neutral reason. Incredibly powerful tool for us. And so The other side of that coin, we're going to talk about comparisons, side-by-side comparisons. You accepted a white juror who was a school teacher, and you said you were striking this black juror because he was a school teacher. The other point that Flowers makes is that disparate questioning can be designed to prevent side-by-side questioning. If I only ask the black jurors what they do for a job, just to stick with that simple example, and then I say, well, I don't want any school teachers, because, school teachers, and that's why. And then the defence lawyer can't stand up and say, yeah, but you accepted 2 white school teachers because no one ever asked them what they did for a job. So disparate questioning can be used to thwart comparative juror analysis or side-by-side analysis. And again, I know that, and you know that, but who knew that a Supreme Court justice knew that? But there it is in Flowers. Disparity in questioning and investigation can produce a record that says little about white prospective jurors and is therefore resistant to characteristic by characteristic comparisons of struck black prospective jurors and seated white jurors. So if you catch them doing that, you don't have to say, oh, you outfoxed me. You can say, they're not asking those questions of those jurors. That's why we don't have a side-by-side, and they don't get away with it because Flowers says they don't get away with it. The other thing to observe about what I'm going to come to in a second, the side-by-side, is this idea that it's not just the questions they ask, but the questions they don't ask. So when you're making your notes and recording what you're doing with disparate questioning, be very careful to think about what they're not asking as well. And I'll come back to that. Again, this disparate questioning requires careful note-taking. But if you're in a jurisdiction where you try cases regularly or cases go to trial regularly and you can talk to and collaborate with the rest of the defence community, the local public defender office who probably handles the majority of the trials, that sort of thing. Most of these prosecutors have got scripts of their own that they've developed just as we do. If you can work out in advance of your trial, what does Joe Smith do in his trials, you can be ready and be taking notes knowing in advance he always goes after their occupation or he always goes after their childcare as an excuse. So you can prepare in advance for your opponent to prove their discriminatory intent. You have to preserve the objection on this basis in the trial court. Once you are doing an appeal in one of these cases and can pore over the record, you can point out this disparate questioning really easily. But appellate judges don't care. They don't want appellate lawyers poring over the transcript unless a trial lawyer has said, Judge, they're asking far more questions of the black jurors than the white jurors. You may not be able to say, as they say in Flowers versus Mississippi, exactly how many. This is what the US Supreme Court did in Flowers. They added up the average number of questions the state asked black jurors compared to white jurors, and were able to say the state asked an average of 29 questions per struck black juror compared to 1 question for each seated white juror. So it's going to be pretty hard to be ticking off how many questions they ask in trial, though you could get, your associate, your assistant to try and do that, just to give you a rough idea, but you'll have seen it. So give your appellate lawyer something to hold on to and stand up and say, Judge, I would need to review the transcript for the exact figure, but we've all been here in court and they were asking at least 3 times as many, at least 10 times as many questions of black jurors as white jurors. Or they were using a different script, Judge. You saw the difference when it was a black juror. They'd ask a whole bunch of different questions. If you can't go into a chapter and verse like you could with the appellate record, you can still say it and make the point, and that'll be enough to have preserved it in the record, or at least as much as we can realistically do in the hurly-burly of voir dire, right? So make sure you preserve the disparate questioning, and then the side-by-side comparison or comparative juror analysis. You're looking at accepted white jurors who shared a characteristic relied upon by the state in their race-neutral reasons. Well, it's a teacher with exams coming up and I think they'll be distracted because of worry about their students and preparing for exams. You got to look at how many white jurors share that characteristic. They knew law enforcement. You got to look at how many white jurors shared that characteristic. One of the things that we've had happen, the Louisiana Supreme Court hates comparative juror analysis, hates it with a passion. It says, well, it's not a fair comparison. Those two jurors aren't similarly sufficient. They don't even have the same last name. They want an identical match between the jurors. And one of the gifts for us out of Flowers versus Mississippi is that the court expressly says, you want a similar juror, but defense will always look for a similar juror, but you do not require an identical juror to come up with an inference of discrimination. So don't fall for that. And in Flowers, they've made it clear you don't need it. And it includes a failure to ask a relevant question. They included that in their analysis in Flowers under this side-by-side comparison. If you're not asking the same question, and in Flowers it was a failure to follow up. Well, do you know anyone? Do you know these people? Oh, they worked at the same store. White jurors, all right, so they just worked at the same store. Black jurors, 20 more questions about how often they'd come in the store, when they'd see them, what period of time. The failure to ask relevant questions is very relevant if the prosecution then stands up and says, well, I'm concerned about how well they knew each other because they worked at the store. You're allowed to stand up and say, wait a minute, he did dig in with this black juror on that issue and ask 25 questions about how well they knew each other because they worked at the store. But if he was really concerned about that, why didn't he ask the white juror who worked at the store as well 20 questions? Why did he give the white juror a pass on that? It's because he's not really concerned about that. It's because he's fishing for a race-neutral reason, because he wants to get rid of the black juror. That's what Flowers in Mississippi was. That's what they came up with. It's going to be relevant, and maybe this is just Louisiana, but it's going to be relevant, that comparative juror analysis is going to be relevant, even if you end up striking that juror, or it's simultaneous strike. Some jurisdictions take it in turns, some do it simultaneously, because it's not important what you think of that juror. It's important what the prosecutor thinks of that juror. And it's important to mention in Louisiana, because the Louisiana statute and the Louisiana Supreme Court both say that if the defense strikes the juror, then they are not to be considered in the Batson analysis. And the Louisiana Supreme Court has said that means you can't take them into account as part of the pattern of strikes, even though the prosecution simultaneously levied a strike against that juror. You can't take them into account, even though that juror was so obviously pro-prosecution that the defense struck her, and that the prosecution can have no reasonable explanation for it. You can't take it into account. For Louisiana practitioners, that's obviously wrong. That will be found unconstitutional when we get into federal court and the Supreme Court. But for the minute, you need to preserve your objection. And I hope for those of you who are from out of town that you're not having to put up with that sort of nonsense either. Requires careful note-taking and a support team, and you need to preserve your objection. Again, appellate courts don't care if an appellate lawyer goes back through and pores over the record and says, oh, they shared this characteristic. I looked at page 4 of the questionnaire and that's where there's something they had in common. No one cares, it's not persuasive, appellate courts don't want it, and they're treating these claims as defaulted in a lot of jurisdictions. You need to get up and say, wait a minute, Judge, there were 2 other white teachers and 3 other white folks who worked at the store, and they accepted them. This isn't about that, it's about race. And if you can't say it chapter and verse in detail, at least say it in generalities. Get it in there that you're seeing it in the heat of battle at the time at trial. Prosecutorial misrepresentations, again, I just had no idea that the Supreme Court justices understood that this was what was going on. When prosecutors misstate the record to justify their strike, that can be evidence to give rise to an inference of discrimination. And what they said, and there's a few examples of it in Flowers, which is, again, you've got to read the opinion, because they talk about a few different jurors. But for one of the jurors, it's the sort of misrepresentation that I think we see a lot. It's not a flat-out contradiction of he's a school teacher, when in fact the person said that they were a cab driver. It's the juror had said that she had a working relationship with the defendant's sister from working at the same place. And the prosecutor went, that was the testimony during voir dire. You know, they worked at the same place, they had a working relationship. Prosecutor stood up in his race-neutral reasons and said, you know, it's this, it's that, she's friends, they were close friends, and the United States Supreme Court singled that out and said, when you stand up and say they're close friends, when the juror's actual answer was, we had a working relationship, that is suggestive of discriminatory intent because you are misstating the evidence. So it doesn't have to be completely contradictory. It's enough if it's an exaggeration. And I don't know how it works where you are, but where we are, prosecutors get up and misstate and exaggerate the responses of the jurors all the time. So that's just a very powerful aspect, again, of Flowers for us. Again, you're not going to catch them in those misrepresentations unless you've got careful note-taking and a support team. And you need to say, it's not very hard to say, that's not what the juror said. You know, you don't have to be able to say the juror's exact words were, I have a working relationship. If you can just say, that's not what the juror said, Your Honour, and it's no good to overstate what the juror said, and that's evidence of discriminatory intent as well. You don't have to do all of it. It's great if you can do all of it, but do some of it. Get it on the record that you're complaining about it. And then I want to spend a minute on this because this is really important. A history of prosecution strikes. Before Batson, we were operating under a case called Swain versus Alabama, which said that if you can show that the prosecution has almost never or never accepted a black juror, then you might be able to bring a 14th Amendment claim. But you cannot prove that by looking at what happened in one trial. You have to show a pattern over a course of years. And no one could meet that standard, right? No one had that. There's only a couple of successful Swain challenges in American history, and a couple of them are from Louisiana because we had a district attorney who said, I'll tell you right now, I'm never going to accept a black juror on a jury in my parish. And said it during the hearing. And just, you know, those cases got reversed, but he knew full well that none of those judges voted in his district. And so he just got up there and said it. But apart from that, no one could win these Swain claims. So then we get to Batson, and Batson changed things dramatically by saying, you can prove discrimination by what happened in your one individual case. And so then courts, particularly in Louisiana, I might say, have said, well, then you don't look at anything else. It's irrelevant. You've got to prove it in this case. And what the court said in Flowers, and it in fact said earlier, is, wait a minute, that's not what we said. We didn't say you couldn't rely on that history stuff. We just said you don't have to rely on that. You can rely on what happened in this case. And in Curtis Flowers' case, it was the same prosecutor, 6 trials in a row, doing it over and over again to the same defendant in a very racially charged county in Mississippi, in a very racially charged case. But critically for us, because none of us are going to be in that position, like, I mean, Flowers is bizarre how that happened, and as the court said, the state took a huge risk when they let that guy prosecute again. It's not going to happen to us probably, hopefully, but the United States Supreme Court did not say you can rely on the actions of that particular prosecutor against that defendant in prior trials in that same case. That's not what they said. They said a relevant history of the state's peremptory strikes in past cases, or, quoting from another section of the judgment, the trial judge may still consider historical evidence of the state's discriminatory peremptory strikes, so not just that individual prosecutor, of the state's discriminatory strikes from past trials in the jurisdiction, just as Swain had allowed. And Swain allowed you to look at everyone else's trial, not just your own prior trials. So in Flowers, the United States Supreme Court expressly gave its imprimatur to looking at the pattern of discriminatory strikes that we see from prosecutors' offices over time. And that's what, remember that chart I showed you at the front, 45% compared to 15% based on 10 years worth of trials in each jurisdiction? That's what we're talking about. And so what we talk about here in Louisiana is these black strike studies, and I included one in your materials. This is one published in 2015 about Caddo Parish, which was bad. They were striking, over 300 trials were studied, and prosecutors were striking at a rate of 3.5 times. So if you look in the electronic materials or in the written printed materials, you'll find this report. There's also a Black Strikes website that's got some of this data, and I included it because it goes through, I don't expect you to be able to read any of that, but it goes through and lays out the mechanics of the jury selection in the district, and it goes through the methodology for gathering the data. So it is a guide for you on how to do this in your own jurisdiction. It goes through the codes that were used in the data, the categories of jury selection, the results, the number of trials from each year that were studied, the overall pattern, which in Caddo Parish looked like that. And what I've always thought was really fun is once you look at 300 trials, you've got enough trials for a statistically valid sample of what individual prosecutors are doing. So you can list, this guy at the top here, Brian Barber, they had 22 of his trials studied, and in those 22 trials, he struck 41% of all black prospective jurors and only 8% of all white prospective jurors, and which is a black strikes rate of 5 times the rate, striking black jurors at 5 times the rate. I'm still trying to work out what that poor white guy did to get struck, you know? I mean, Jason Brown, Lee Hall, those guys both got kicked out of that DA's office after a reform-ish DA got elected, an African-American DA, but they both got picked up in Lake Charles in Calcasieu Parish in Louisiana, which has become a gathering spot for a sort of a rogues gallery of people who've been tainted elsewhere. Brady O'Callaghan, 47% of black jurors, 19% of white jurors, 2.5 times the rate. He's a judge now. So one of the really valuable things that you can do with this data is think about, well, I'm trying a case in front of Brady O'Callaghan, who used to be a DA in this district and himself struck black jurors at 2.5 times the rate. How are we going to make this work? I don't actually have an answer for that. I do have a phone number if you're held in contempt, but you know, it's a pretty interesting thing, right? Because in Louisiana, a lot of these judges are former prosecutors. So have a look at that study, and I really encourage us as a defence community to replicate these studies. We've done them in a bunch of jurisdictions here in Louisiana, and we should be doing them in our home jurisdictions. We're going to need public and private partnerships. No private law office is going to have the money to do that, and the public defenders probably don't. But if your local ACDL chapter, whether it's the LACDL or something else, can help coordinate the private bar and the local defenders and the local law school or criminal justice course, maybe you can pull the resources together to replicate a study like this. It's tremendously powerful. And as I indicated in that bottom dot point, you can preserve this objection pre-trial. We file objections pre-trial sometimes with these statistics saying we want them to be barred from using peremptory strikes because of how they've abused them in the past. We don't expect them to be granted, but it's a way of getting all that evidence into the record before you go to trial, so then you can refer back to it when you make your Batson objection. It's a way of pushing back on them. Now you've got to be ready to take them on, right? I mean, we had Jim Craig, who was working at my office at the time, filed this against Dale Cox, one of the prosecutors that was on that list I showed you. He was apoplectic. He was talking about bar complaints and sanctions and demanded that this motion alleging discriminatory pattern be withdrawn. And Jim said in court, Judge, I'm very concerned about Mr. Cox's allegations. If they are incorrect, we will withdraw the motion with an apology. So I'd like us to bring it back in 2 weeks' time. We're coming back, and I will withdraw the motion if what Mr. Cox says is right, that our statistics are wrong and that we're making that allegation incorrectly. Jim went back and pulled out Dale's personal statistics, which showed that he had an even higher rate of disparate strikes than the average in what was already a blighted office. And so he refiled a new motion with the new data saying not only are we not withdrawing it, but we're doubling down and saying you're one of the worst offenders. No Christmas card that year, but you've got to be courageous when you take these things on, but it's a great opportunity to litigate some of these things and put them on the back foot. You can preserve the objection during voir dire. In fact, there's some Louisiana case law that says that's the only place you can do it. And you can do it in a motion for new trial. If you can't pull a whole bunch of this stuff together, use a motion for new trial. Most jurisdictions have got a capacity at motion for new trial to do something. Put on some new evidence, show a legal error you couldn't prove before. The court also has the catch-all, all other relevant circumstances are to be taken into account. So this list includes number 6, which is everything else. I want to mention a couple of them. Things that are proxies for race. Residence, lives in the black part of town. He lives too close to the crime scene. Well, where are all the crime scenes? Knew too many of the people, part of that community. These are proxies for race. No one gets away with them in employment law or voter rights or any of those sorts of things. Equal protection works there and we understand it. And there's good case law saying you can't use those proxies either. Assumptions about intelligence and demeanour. And one more war story, another one of my staff, Megan Shapiro, was trying a case. It had been capital, they took death off. She's trying it, African-American defendant. She raises a Batson challenge, it's rejected. They're going through another panel. They're sitting there waiting for the judge to come into the judge's law library where they're doing the challenges. And she overhears the prosecutor and the second chair talking. And the second chair says, but we don't have a good reason for that strike. And the district attorney says, yes, we do, he's stupid. So the judge comes in and sure enough, they strike this African-American juror. And Megan says, well, look, we object, Batson. And he gets up and gives his race-neutral reason. Well, I looked at his demeanour and he didn't look that interested and he was, wasn't paying attention. And Megan got up and said, well, look, it's 5 o'clock. They've been here all day. He looked as interested as everyone else. And just 5 minutes ago, she said to him, we don't have a good reason. And he said, because he's stupid. I don't know whether I would have had the guts to put that on the record. And I was raised never to disclose what other counsel said. So I don't know if I instinctively would have done it. But Megan's taught me a lot because they were discriminating based on race. He thinks he's a stupid black guy because that's how that came out. And maybe we should. But we did in that case. The judge said no. I went away for 15 minutes and said, no, I'm denying the challenge. We came back on motion for new trial and we called the black juror who gave evidence that he had graduated from high school, held a job for the last 26 years, was a deacon in his local church where he assisted with the annual budgeting and the financial affairs of the church, etc., etc. They had an appellate prosecutor come down and cross-examine him for an hour about, well, when you say you graduated, was it a regular diploma? And I mean, it was a hell of a thing. And the judge reversed his ruling and said, you know what? They were relying on a racist trope about ignorant black people. He didn't ask him any questions. And we put on this witness to say they didn't ask him a question about his education or his intellectual functioning. And if they had, they would have found out that this guy is completely fine. And they didn't ask because they don't care because they were operating on racist assumptions. And we won the Batson objection at motion for new trial. One other thing to mention is statements outside of voir dire. In Snyder versus Louisiana, which is reported in the US Supreme Court, the prosecutor was heard going around saying, this is my OJ case. There was a car chase in it, so he thought that this was his OJ Simpson case. Jefferson Parish, so don't worry about how the OJ Simpson case divides people. It didn't divide anyone out in Jefferson Parish. They all thought he was guilty. And, so then the defence moved pre-trial and said, you can't be talking about OJ. And the prosecutor said, I don't need an order, Judge. I know the rules. I have no intention of talking about it, until penalty phase rebuttal closing where he got up and said, this is just like OJ Simpson. And both the Louisiana Supreme Court in dissent and the US Supreme Court noticed that And there was a phrase from the dissenting justice in the Louisiana Supreme Court. I wonder whether he would have used that phrase if he'd not struck every single black juror from the jury. So what they're saying in the media beforehand can matter. What they say during the trial can matter. You can re-urge your Batson objection as a result of something they say during the trial. In the case I was talking about where he struck the black juror because he thought he was stupid, he then got up and started talking about and using black tropes of these people on the street and these gangsters and that sort of stuff. And we said he was aiming to use racially coded language, and that's why he was striking black people, and so that supports the inference. So don't give up. You can use anything they said before and after trial. I know I'm going to run just a couple of minutes over. No, I'm not, says Gerald. He just showed me the 2 minutes I had or something like it. So I'm going to go quick. All of these things support an inference. So you don't have to wait to step 3 to say them. You can use them to show a prima facie case. But once you get to step 3, you need to get up before that judge says, I accept the reason, and say, Judge, I've got rebuttal. Because as you've seen from that list, it's all about proving that those reasons aren't true. So you've got to get up and prove, was the strike motivated in substantial part, not entirely, by discriminatory intent? And as Flowers emphasises, are the proffered reasons the actual reasons, or are they pretextual? And in order to do that, you need the court to give you, and you need to demand, a distinct rebuttal stage where you get up and demonstrate the disparate questioning, demonstrate the side-by-side comparison and all of those other things. And there's great language in Flowers about how the decision must consider the race-neutral reasons in light of all the relevant facts and circumstances and the argument of counsel. You have to be allowed to get up and argue, and you have to demand that space. So the takeaways: read Flowers versus Mississippi, prepare before your trial to be ready to make and support your Batson claim, replicate those black strike studies in your jurisdiction, and for goodness sake, don't go into voir dire on your own. Take a team, because it's the only way we can meet the modern standard for bringing these Batson objections. Thank you all very much for your attention.